Hello, I'm Brenna Bay, a partner with Edwin Co. Welcome to our podcast series about residential construction. In these podcasts, we discuss matters which arise on residential construction projects. Numerous of the topics discussed in these podcasts are also covered in our guide entitled What to Know Before You Start Digging a Hole, which can be found on our website. I would highlight that the information within these podcasts is general guidance only and may not necessarily apply to your particular situation, since every construction project is different. Therefore, I strongly recommend that you seek professional advice before you undertake any sort of construction project or sign any appointment or contract. In our last podcast, we discussed defects, identifying what exactly qualifies as a defect, outlining responsibilities for defects, and considering an employer's options when a contractor does not fix defects. In this podcast, we will talk through the common forms of dispute resolution used in residential construction, being negotiation, mediation, adjudication, arbitration, and litigation. As outlined in our earlier podcasts, a key method for mitigating construction disputes is for parties to take the time at the outset of the works to properly document their expectations and agreed obligations within a written contract. Of course, even with a well-considered contract, disagreements arise. The first step in relation to any dispute should always be a discussion and negotiation between the employer and contractor, since this will often be the quickest and most cost-effective form of dispute resolution. It is also the method which is most likely to preserve good relations between the parties. With regard to formal dispute resolution, the options will depend on the contract provisions, or in the absence of a contract, the nature of the employer. Usually, the method of dispute resolution which comes first to mind is a court claim. A formal, public, legal procedure, litigation has lengthy processes covering pleadings, witness statements, disclosure of information, and collation of expert reports, all culminating into a court hearing. While the successful party might be awarded an element of the costs which it incurred in the claim, it is unlikely that a party will recoup all of its costs. Hence, generally, litigation is the most time-consuming and costly method of dispute resolution. Additionally, as discussed further shortly, litigation is not always an option, depending on one's contract provisions. Given the time and cost implications of litigation, alternative forms of dispute resolution have evolved. These other forms, which include mediation, adjudication, and arbitration, are typically, although not necessarily, thought to be quicker and less costly than litigation. Let's look first at mediation. Where attempts between parties to resolve the dispute through discussion and negotiation has failed, mediation is often the next step. Mediation is basically an extension of the negotiation to settle the dispute with the assistance of an independent third party. The mediator's role is not to decide as between the parties. Rather, it is to facilitate an agreement which meets both parties' requirements, resulting in a settlement. The advantages of mediation are that it is flexible, fairly quick, and generally low cost. If successful, the parties will emerge with a settlement agreement. That being said, where mediation is undertaken at the outset of a dispute, the parties might not yet be in a position to settle due to lack of information as to the merits of the claim. Additionally, any settlement agreement is contractual and thus itself can be breached, potentially leaving the wronged party in the same position as when it started. Whether or not the parties need to mediate will be dependent upon the terms of the contract. Generally, parties to a construction contract have a statutory right to use adjudication for dispute resolution. The exception is where one of the parties is a residential occupier, being someone who occupies or intends to occupy the property as their residence. Even though statutory adjudication will not apply, residential occupiers can contractually agree to use adjudication. Usually, contractual adjudication is optional. That is, a party can choose to adjudicate, but does not have to do so if it has a claim. However, this will of course be dependent upon the contract. As well, if one party starts an adjudication, the other will have to participate, as otherwise a decision could be made against the second party. Adjudication is a quick method of dispute resolution which can be used during the course of the project so that the works can continue and the contractor can be paid with minimal delay. Generally, an adjudicator is required to reach his or her decision within 28 days of the referral of the dispute to the adjudicator. The adjudicator's decision is temporarily binding and must be complied with until the decision is overturned by a court or through arbitration. Given its quick nature, adjudication is often characterized as rough justice and not suitable for complex disputes. The limited time frame is considered by some to be unfair to a residential occupier, given his or her lack of experience with construction matters, as compared to contractors or construction professionals. Yet, adjudication has been a successful form of dispute resolution within the industry for over 25 years, and the vast majority of participants adhere to adjudicators' decisions. Additionally, almost all of the industry standard forms of contract and appointment include provision for contractual adjudication. Furthermore, residential occupiers can avail themselves to the benefits of adjudication in relation to claims for defective works and overpayments, just as easily as contractors can use adjudication for payment issues. The final form of dispute resolution which we'll consider is arbitration. Arbitration provides for formal dispute resolution determined by a tribunal, typically comprised of either one or three arbitrators. The tribunal focuses on the issues of fact and law presented by the parties in a process similar to litigation, with pleadings, disclosure, witness statements, expert reports, and potentially a hearing. Arbitration is less formal than litigation and is private. Additionally, as compared to litigation, arbitration provides more flexibility, as the parties are able to determine everything from the makeup of the tribunal and number of arbitrators, as well as which rules of arbitration will be followed. While there can be clear benefits on larger international projects, for residential construction projects, arbitration is frequently more time-consuming and costly than adjudication, and in some cases litigation. Importantly, an arbitration award is final and binding on the parties. This means that there is no recourse or appeal, save in extremely limited circumstances. What is key for those filling in standard form contracts and appointments to understand is that if the contract is indicated as including an arbitration clause, i.e., arbitration is stipulated as applying, then any dispute arising under the contract must be referred to arbitration rather than litigation. Therefore, it is strongly recommended that parties seek professional advice prior to concluding a contract or appointment to ensure they understand the form of dispute resolution which would be applicable to their contract. So in this podcast, we've looked at common forms of dispute resolution used in residential construction, including negotiation, mediation, adjudication, arbitration, and litigation. While entering into a proper written contract can mitigate areas of uncertainty as to the parties' obligations and responsibilities, given that construction involves designing and building a bespoke product, disagreements and disputes do arise. The cost in respect of both time and money of pursuing a claim through formal dispute resolution processes is often disproportional to what a successful party will recover. As well, relations between the parties will undoubtedly sour once arbitration or litigation is commenced. Therefore, seeking to settle the matter through discussion and negotiation should always be a first consideration. Since each of mediation, adjudication, arbitration, and litigation has its advantages and disadvantages, it is critical to consider the options prior to entering into your contract or appointment, so that in the event of a disagreement, you are able to use the form of dispute resolution most appropriate for you and your project. I hope you've enjoyed this podcast and will join us again next time.